Hello, my name is Socrates, and the concepts presented may offend you. Enjoy.
When Emperor Justinian I wrote the Code of Justinian, he depicted the first speculations on the functions of law, as well as the practicality. In seeing the aftermath of both historical and modern trials, the ability of the citizen to either effectively participate in their community with good intentions or place judgments on those who transgressed against the state or their neighbors, without any well-noted risks of being treated equal to or worse, can you say that if one law or the practice or processing an offense is impeded by freedoms that the state endorses, there is law at all? As with many practices of law enforcement, to place a trap is a considerable method. Though if there are prerequisites for the use of or collection of evidence, that itself is the state endorsement of the offense. When approaching the law realistically, there are factors in the participants' minds that could either imbalance the perception of a situation or levy a logical abortion. Thus, to say that the law can be upheld implies as well there are legal prerequisites to citizenship, dully to pose thought relevance to legislative practices otherwise with acknowledgments in reference, then the facts stand. There is no interest in the development of a practice by which litigation without tamperings relevant to such cases in which the circumstances that exclude true citizens the accessibility to safety. Where not one who could be filmed performing heinous crimes have such tapes thrown out circumstantially due to the method of collection? Such is the same in reference to the matters of securing leniency, where one could face to their own regard excessive charges and full-length sentences, if so they do not propose there be restrictions to which the evidence in a courtroom could be invalidated. In Canada, the administration refers to most any collective hand of the governing body, thus by which to mark the Charter of Rights and Freedoms, that there have been notable preparations set aside to create a matter of impracticality in the functions of the criminal justice system. The administration itself can disregard evidence against itself in the case that such evidence would defame said administration. So dully to say that in either case by which the law successfully protects its citizens from each other, or the lapses in judgments by either first responders, investigators, barristers or the legislative body, to say in other words, the functionality of the laws can only be noted when logical coherency is able to stably produce either a conviction or acquittal, when the accused's defense relies on the discreditation of concrete evidence. Need one further note the overturning of a evidence, leading to a false acquittal, can be both situationally devastating to both the victims and their families, but entirely degrade the logical consistency when approaching cases based in relative circumstance. Thus why case law should be for reference, to be able to approach the dismantling of legislature when publicly noted to malfunction, if so the wording of simple statements has come to be too complicated for folks whose combined salary could be submitted as grants to the philosophy departments of domestic or foreign universities. It's literally the job description. Like, subscribe and click the bell for notifications.